All right.
Calling the matter of Jessica Allor versus Adam Bishop.
For the record, this matter is before the court on the defendant's motion for tax exemption for the children and to prevent a change in the school district of the minor child. This hearing is being conducted via Zoom. Present is the plaintiff mother, Jessica Allor. In addition, attorney Leslie Carr is present representing the defendant, moving party, Adam Bishop. Mr. Bishop is present. The parties have conferred at length this morning with Mr. Walker from the front of the court, who has provided the court with a fine recommendation that the minor child shall remain in Bedford Public Schools until further order of the court, unless the parties agree otherwise. Further, the party shall claim alternating the minor child for tax purposes. Father shall claim even tax years, mother shall claim odd tax years. Finally, the parties will mediate with Mr. Walker on December 18th, 2024 at 1:30 p.m. via Zoom to further discuss parenting time and child support. That is the recommendation. Mr. Carr, is this recommendation agreeable with your client, Mr. Bishop, this morning?
Yes, it is. Thank you, Your Honor.
Thank you, Ms. Carr. Ms. Allor, do you understand the recommendation?
I do, yes.
If the court adopts it, it'll become an order of the court. Do you have any objection to the court adopting this recommendation?
No.
Okay. Ms. Carr, is it necessary? Do you want to voir dire Mr. Bishop? Obviously, you did participate in the discussions.
No, there's no need.
All right. Very well, the court would like to thank Mr. Walker for his assistance in helping to facilitate this resolution this morning. The court will adopt the recommendation. Of course, the court will be available on December 18th if you want to put anything on the record, Ms. Carr.
Great.
Mr. Bishop, Ms. Allor, keep your mind open as you engage in mediation, because any agreement between the two of you is far better off than having a third party like the court make these decisions. You know what's best for your respective schedules and that of your child. So you should be able to make that decision with the assistance of Mr. Walker from the front of the court. All right, that will conclude this hearing. The court will adopt the recommendation. Everyone can zoom out. Have a good rest of the morning.
Thank you, Your Honor.
Thank you, you as well.
On the matter of Hope
Thank you.
versus David Cesak.
For the record, this matter is before the court to review of any outstanding issues, which I believe are primarily parenting time. This hearing is being conducted via Zoom. Hope Smith, plaintiff mother, is present. Is David Cesak present? On audio, it appears that he has not appeared this morning. The matter was scheduled at 10 a.m. It's now 10:25. Ms. Smith, when did you last, can you text Mr. Cesak to remind him? Maybe he forgot.
I don't feel comfortable messaging him.
When did you last see him? Is he exercising parenting time?
He is not exercising parenting time.
Mr. Barrow, the court notes that this matter was referred to the front of the court for a formal investigation recommendation. The court has not received anything from the front of the court. Has that occurred?
Yes, that has been completed. The recommendation is in the file from Ms. Sisk at the front of the court.
Okay. I guess I missed that.
I can send a copy up to Ms. Frazee if you would prefer.
No, I'd like to get in the court file. I'm gonna have Andrea go down to the clerk's office and find that. And it was filed October 30th, November 30th, or I'm sorry, October 30th.
October 30th, yes, Your Honor.
3 weeks ago. All right. Yeah, we're gonna find that this morning. We can go downstairs and find that, please. Of course, the last order of this court, Mr. Cesak was present. He was aware of today's review at 10 a.m. The recommendation this morning, noting that Mr. Cesak failed to appear, is that his parenting time remains suspended until he completes an anger management program, enrolls in counseling and motions court, and Leanne Shaktoon counseling. So, Ms. Smith, Mr. Cesak has not contacted Leanne since we were last in court. Is that correct? September 24th?
That's correct.
Almost 2 months. Has he texted him, reached out to him, FaceTime, any contact?
I'm not sure my son wants contact with him. My son hasn't reached out to him, so yeah.
All right. All right, so the court will adopt the recommendation this morning. Do you have any questions, Ms. Smith?
I don't.
Obviously, Leon needs a father in his life, so you've got to encourage that.
I do agree he needs a father, but the influence that his dad has had on him has impacted my son very negatively. There's another CPS investigation against David, like currently going on. That was made through my son's teacher. My son's counselor, I don't know if you have the letter in front of you, but she sees that it's unfit for David to be around Leon. Just the things that he tells me that his dad says to him, I mean, I would constitute as abuse. And I work at a school. I deal with kids every single day. And so like part of my job is noticing patterns of abusive behavior, and that I've noticed that in my own child. So at this point, my son does not feel comfortable going over there or reaching out even via text.
All right, the court will adopt Ms. Brower's recommendation. His parenting time remains suspended until he petitions the court and has completed the anger management counseling program. All right, you'll be mailed a copy of this order. So that will conclude this hearing. You can zoom out, have a good rest of the day.
All right. Thank you, Your Honor.
Good morning, Ms. Hicks.
Morning, Your Honor.
Ms. Gorski, who are you representing this morning?
Morning, Your Honor. I'm with Ms. Mclofflin, so we are here to listen.
All right, for the record, this matter is before the court, the request of the Monroe County Front of the Court Attorney, Rebecca Hicks. Brandon Thomas is also present, presumably the payer of support. Lexi Mclofflin, plaintiff mother, is present with her attorney, Maria Zagorski. Good morning, everyone.
Good morning.
Morning.
Morning, Judge.
Okay, the court will assume, Ms. Hicks, you're bringing Mr. Thomas before the court due to outstanding child support arrearages. Is that correct?
That is correct, Your Honor.
Can you give the court a little background information?
Absolutely. In this case, Your Honor, there is a current monthly support obligation of $1,072. This case ended up on the docket today after being elevated from a hearing with referee McKee on October 16th. This case is the commence date of support is March 1st of 2024. It was ordered in May of this year and was programmed in May of this year. Until yesterday, Mr. Thomas had not made a single payment. Yesterday, he did come in and make a payment of $110. However, that's less than 10% of current monthly support obligation. He is employed, Your Honor. We have had some back and forth issues with his employer. When we send income withholding, they send us documentation saying that he doesn't work there, but then they've sent us documentation of his earnings of working there. So while we have not managed to get income withholding in place, we are aware that he is employed. He states he's employed, and he's just not making payments on this child support. So at this time, the friend of the court is requesting a finding of contempt.
How much are the arrears as of today's date, Ms. Hicks?
After that payment of $110, they are $9,566.
Okay. All right, thank you. Mr. Thomas, you heard all that, correct?
Yes, sir.
I'm sorry?
Yes, sir.
Okay, and of course, if your employer is not to, you need to pay it directly until you see it come out of your paycheck.
Yes, sir.
So this is pretty significant arrearage. You get much over $10,000, your attorney general will be looking for you and charging you with a felony charge of felony non-support. You'll be on the radar very soon if you don't take care of reduce significantly these arrearages. So you need to be proactive. If you're unemployed, you're injured, you need to be filing motion to reduce support. But until you do that, that's going to keep adding up additional $1,072 per month. These arrears are through October, Ms. Hicks, or November?
That did include November's support amount, Your Honor. Through the end of October, it was $8,604.
Right. All right, Mr. Thomas, the front of the court is asking the court hold you in contempt. You understand if you were found in contempt, you could be ordered to serve up to 45 days in jail. because of the distinct possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all of that?
Yes, sir.
Okay, do you want a court-appointed attorney, Mr. Thomas?
Yes, sir.
Okay, let me ask you a few questions. Why don't you provide the court with a cell number that the attorney can reach you at?
734.
What's the name of your employer? Are you currently employed still?
Yes, sir. TA Travel Centers.
You working full-time?
They actually just dropped us down to part-time.
Okay. Well, the front of the court, first of all, has a 4-page list of employers that are screaming for employees. Would the court suggest you come out in front of the court today and get that list and get a job full-time? And if you're, in fact, you've got some decreased income, you need to be proactive. Don't sit on your hands. You go in and file a motion to reduce your support until you can get full-time employment, Mr. Thomas. There's things you can do. Otherwise, you're going to keep tagging along and adding $1,000 every month. Okay,
Yes.
do you own this? Your address is 6.
Yes, sir.
Do you own the home or do you rent?
I rent.
Okay. How long have you worked for a TA Travel Center?
Since I've been out of jail, it's been almost 2 years now.
Okay. And you were full-time until just recently?
Yep, until about a month ago.
Okay. I mean, that's the sure triggered you're going down in front of the court and filing a motion to reduce support immediately once your hours were reduced. So how many hours are you working right now? 20 hours?
It's 31 or 32
Okay. Do you get paid every week?
every other week.
Okay. What's your average take home every 2 weeks?
About 1,000, 1,100.
Do you have any other income?
No.
Do you own any assets of any value? Automobile?
Nope.
Bank accounts?
Nope.
All right. The court will grant your request for court-appointed attorney.
Do I request an attorney?
The court is granting your request.
Okay. Yes,
The
sir.
attorney will contact you on your cell number of 69. So typically, here's what the court's going to do, Mr. Thomas. The court's going to order you to personally appear in Judge Brock's court, 4th floor of the courthouse. And you need to bring with you some cash to make a significant payment towards the arrearages, or bring your toothbrush, because there's a distinct possibility you're going to go to jail, Mr. Thomas.
Yes,
So
sir.
the court suggests is you need to file a motion to reduce support, get to that jobs list in front of the court today, and reach out to family and friends. I mean, obviously, if you understand that you were reduced part-time a month ago, but before that, I don't know what happened to that money, but obviously, hopefully you're putting that aside and you've got it safe at home so you can make significant payment toward these arrearages. Ms. Hicks, what amount do you think is reasonable for Mr. Thomas to bring in?
At a minimum, current support, Your Honor, of $1,072 at a bare minimum.
That's most reasonable with this kind of arrearages. So, Mr. Thomas, how long is it going to take you to come up with $1,072?
I can ask family and friends and see if I can get it as soon as possible.
When do you get paid? When do you next get paid?
Can I look at my calendar real quick? I don't know if I exit out or not. I think it's 2 weeks. 2 weeks.
So you just got paid?
I'm pretty sure. Last Friday.
Okay. So you got $1,000 on Friday, correct?
Yes, sir.
Okay. Do you have that still available? You come in and pay it?
I do not, sir. I had my rent to do, phone bill to do, and internet. So I do not have that right now, but I can try and find it.
You need to reduce your expenses, Mr. Thompson. You need to file a motion to reduce support if you can't afford this.
Okay, I did not know I could reduce the support.
Well, if you break your leg and you're injured and you're unemployed, yeah, absolutely. But you've got to take affirmative action. You can't sit on your hands.
Yes, sir.
All right, so the court's going to order you to appear. I'm going to give you some time, Mr. Thompson. I want you to remain out of jail for the Thanksgiving holiday. So I'm going to order you to personally appear on Monday, November 25. I'm going to give you a few days to come up with this money.
Yes, sir.
And you're personally appeared November 25, 11:15 a.m. and have paid. I'm suggesting if you want to avoid immediate jail, you need to pay a minimum of $1,072 on that date or before.
Is that including the $110 I just put down too?
No, sir.
Okay. Yes, sir.
$1,072, $1,000 won't do it. It's gotta be $1,072, and you gotta pay cash at the front of the court. So if you've got the money, pay it before you spend on something else. And if you don't have that, there's a really, really good chance that you go to jail on November 25th.
Yes, sir.
And if you can pay that, the court will reserve. The court will find you in contempt. But the court will reserve sentencing. It will basically hand you the key to the jail. You can avoid jail as long as you really need to address this obligation. So, Mr. Thomas, you need to file a motion to reduce support. You need to get another job. I mean, you need to move in that direction to take care of this.
Yes, sir.
All right. Do you have any questions?
No, sir.
Ms. Hicks, anything further?
Nothing further, Your Honor. I'll prepare that order and get it uploaded.
So again, appear in person November 25 at 11:15. The trainer will contact you between now and then, Mr. Thomas. Ms. Sikorsky, anything further on behalf of Ms. Mclofflin?
No, thank you, Your Honor.
Okay. All right. That'll conclude this hearing. Now we're going to zoom out. Have a good rest of the day.
Thank you, Judge.
Thank you.
Thank you.
Mr. Levy, you had a chance to talk with Mr. Thomas?
Yes, I have, Your Honor. It was my understanding that he was going to pay the amount in arrearage as recommended by Ms. Hicks. He said he was going to do it, so I guess I'll rely on Ms. Hicks to fill those blanks in.
Okay, we can call the case when Ms. Hicks is ready.
Calling the matter of Lexi Mclofflin versus Brandon Thomas.
For the record, Mr. Thomas is personally present as ordered by this court last week. The court did appoint Mr. Timothy Later to represent Mr. Thomas regarding this requested contempt finding. The court also suggested that he pay the current monthly support obligation, which is $1,072 before he appeared today. Also present on the Zoom Polycom is Attorney Timothy Later and Monroe County Federal Court Attorney Rebecca Hicks. Good morning, Mr. Later, Ms. Hicks.
Morning.
Your Honor, good morning.
Ms. Hicks, have you been able to verify that Mr. Thomas paid $1,072?
Yes, Your Honor. We received two payments, one of $800 and one of $273 for a total of $1,073.
Wonderful. Good morning, Mr. Thomas. Did you also pick up from the front of the court a form motion to modify support?
I was going to do that today after.
Okay. Those forms don't cost anything. You could pick those up, and the sooner you get it filed, the sooner you get relief. So you should have done that last week when you made a payment. So just talk to your caseworker. Maybe the front one, they can give you just a support modification packet. Just be proactive. So I'm pleased you made that payment. Ms. Hicks, in light of the fact that Mr. Thomas paid that, what is your request this morning?
Your Honor, the front of the court is still requesting that Mr. Thomas admit to contempt as he had money and income coming in and had not made any payments. Obviously, we're not asking for any immediate jail. Instead, we would adjourn this matter over to monitor that he starts making his payments moving forward, as this is a substantial current support obligation. And until he files a motion to modify, it's going to continue accumulating at that $1,072 a month.
All right, thank you. So, Mr. Thomas, what's being requested for the front of the court, this court hold you in contempt of court for failure to pay support when you've had the ability and income to do so. Already served 45 days, but suspend that. So in other words, I'm handing the key to you. You can avoid any jail, not even a day, if you just simply address this obligation. Yes, first thing to do is file a motion to reduce support. I mean, just be proactive. Don't sit in your hands. Yes, and the other thing, you got to make some payments in the meantime. This should be your first obligation every month is this child support, because your other, and I understand other bills are important too, electric bills, car payments, but again, you can't go to jail for those bills. So just make a good faith effort. Mr. Thomas, why don't you first of all state your name and current address for the record? Is that correct?
Yes, sir.
Mr. Thomas, have you satisfied you received your right to legal counsel by conferring with Mr. Later?
Yes, sir.
Is it your intention to admit to contempt this morning?
Yes, sir.
You understand what the court will do, and there will be no hearing at all this morning. The court will simply take the best way for you. I'll give you a date for review And again, if you comply with everything, then you can avoid any jail. You hold the key to the jail.
Yes, sir.
But of course, if you don't, you're buying yourself some time. Right, Mr. Thomas, raise your right hand to be sworn then. You solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
And Mr. Thomas, do you admit and acknowledge that you are obligated to pay child support pursuant to order of this court for the benefit of a child or children born to you in Lexi Mclofflin?
Yes, sir.
Do you admit and acknowledge you have outstanding arrearages about $9,500?
Yes, sir.
And you acknowledge that your current monthly obligation is $1,072?
Yes, sir.
It's been, the court's been informed that you last made a payment on November 18th, $110. You admit and acknowledge that over the past, since the original order was entered back in, I think, March of 2024, you've had income and you've not made regular payments toward your support.
Yes, sir.
Ms. Hicks, you have any questions for Mr. Thomas?
No, Your Honor, no additional questions. Thank you.
Mr. Leiter, do you have any questions for Mr. Thomas?
No, I do not, Your Honor.
Right, the court finds that a supporter exists in this case. Mr. Thomas acknowledges his obligation, acknowledges that income and has not paid that toward his child support. With the arrearages being approximately $9,500, the court finds Mr. Thomas to be in contempt of court for his failure to take timely action to address this obligation. Ms. Hicks, what do you suggest for a review date for Mr. Thomas? We put this back on your docket.
Yes, Your Honor, January 14th at 10 a.m.
Mr. Thomas, are you currently employed?
Yes, sir.
Do you have regular paychecks?
Yes, sir. Every 2 weeks.
Okay, good. So do your best. The court will order you to serve 45 days in jail, but reserve that sentence. So hand you the key to the jail. You will not do any of it unless you put yourself there. You ordered to appear for Ms. Hicks on January 14th at 10 a.m. If you're working that day, you can appear by Zoom. And all she wants to see is that, number one, you've filed the motion to reduce your support, and secondly, you're making some payments. If you can't afford the full $1,002, make a good faith effort. You're paying as much as you can. Primary thing is get that motion packet today to reduce your support and get it filed as soon as possible. There's a filing fee for that. What's the filing fee? Is it a $20 motion fee, Ms. Hicks?
I'm not 100% sure what the filing fee is currently for a support motion, Your Honor, but they would tell him at the front desk when he picks that up.
Okay. Right, there is a motion filing fee. Get that paid as soon as possible. Just so, because the sooner you file it, the sooner your relief can go retroactive the date you filed it. Even though maybe your hearing is not maybe till end of December, early January, they'll go back to the date you filed your petition.
Yes, sir.
So get it filed as soon as possible. And Mr. Thomas, the front of the court will mail you notice that your review is January 14th, 10 a.m. Any questions?
No, sir.
Okay, anything else, Ms. Hicks? Mr. Leiter?
Nothing further,
No,
Your
Your
Honor.
Honor. We do certainly thank Ms. Hicks as well as the court.
Thank you, Mr. Leiter, for your assistance. And right, how much? 60. That's an odd number. Okay, for a $60 motion filing fee.
Yes, sir.
So get that paid, get it filed as soon as possible. It's in your best interest. Right, Mr. Thomas, you're all set.
Thank you.
Have a good rest of the day. Have a good Thanksgiving.
Thank you.
And tell your mother I said hello, okay? Nice young man.
Your Honor, I'm sure that Thanksgiving dinner where he can eat it somewhere outside sure beats the Thanksgiving dinner at the Monroe County Jail, so.
I hear they have pretty good food over there.
Well, fortunately, I've never had the opportunity.
All right, thanks, Mr. Leiter. Have a good rest
Thank
of
you,
the day.
Your
Have a good
Honor.
Thanksgiving.
You too, sir.
Ms. Hicks, you have some cleanup matters.
I do, Your Honor.
The record this matters before the court on the plaintiff's motion for modification parenting time, as well as place a motion for her to show cause. This hearing is conducted via Zoom. President's Attorney Kirsten Nemec representing the plaintiff, the moving party, Vanessa Walch. Ms. Walch is present. Is Christopher Manini present on audio? It appears that he is not. This matter was scheduled for hearing at 11 a.m. It's now 11:30 a.m. Court file reflects that a copy of the motion and notice of hearing was mailed to Mr. Manini at the address of 40. Ms. Brower, is that the current address that your office has on file for Mr. Manini?
One moment, Your Honor. Your Honor, Mr. Manini has a confidential address with the front of the court.
Okay. If that confidential address is something different than the one that this motion was mailed to, we need to adjourn this matter.
We can adjourn this, Your Honor.
Your Honor, we do know that he received it because he communicated the same to Ms. Welch. He also communicated that he was going to seek to have the case reassigned to a different judge. So we do know that he received the motion.
Can Ms. Walch text him and tell him the court's waiting for him?
Okay. She's on her phone right now, but it appears that that's what she's doing. Are you able to see if he's read it? Does he have read receipts on?
We have the court app, so yeah, he has not read.
Okay.
He's probably at work. Yeah, because he didn't move until just after this week, and he got it before Halloween.
Okay.
He received the letter.
Okay, what are you referring to, Ms. Walch? What did he receive?
The motion.
Okay, and then how do you know that?
He called me not very nicely, not saying very nice words to me.
Okay, but he said that he had received a notice to come to court.
Yes.
Motion. All right, court will accept that as a notice. And who lives at the 8th Street address? Is that Mr. Manini's parents?
I'm not quite sure which one that is.
The 405 West 8th Street. That's where we mailed everything, where he received, where he lived prior to moving to Toledo.
Yes, that was him and his girlfriend lived there.
Okay. Apparently, Ms. Nimick, your client has reason to believe he's moved to Toledo. Is that correct?
He moved to Toledo just last week.
Okay. Well, a reasonable person would provide post service with a forwarding address. So based upon the statement of Ms. Welch that she did discuss this motion and the court date with Mr. Manini, the court will proceed. Ms. Browers provide the court with following recommendation. The allegations, Ms. Nemick, is that Mr. Manini has not been exercising parenting time to which he's been awarded. He's been sporadic. Is that correct?
That is correct.
And also he's failed to contribute toward extracurricular expenses as previously ordered. Is that correct?
That is correct.
The recommendation this morning, Ms. Browers, that father's parenting time should be every other weekend, Fridays at 4:30 p.m. to Monday to school, or 8:15 if there's no school, commencing in November 29th, 2024. The party shall meet at the Meyer gas station on Lexus Road and Hagman Road for the exchanges. Where do the children go to school? In Bedford?
Mason.
Mason, okay. So presumably, Mr. Manini can facilitate their attendance at school on Monday mornings from Toledo to Mason. Further, it's recommended that the defendant, Mr. Manini, reimburse plaintiff $577.62 for his half of the children's extracurricular activities through November 2024, and the defendant shall pay an amount directly to the plaintiff by December 19th, 2024. That's recommendation. Ms. Nimick, is this recommendation good with your client this morning?
It is, Your Honor.
Right, Ms. Welch, any response from Mr. Manini from your text this morning?
Nope. I have not received any text. I got a text message from him this morning, but I have not received anything that after I just messaged him.
Okay. His communication this morning, did it have to do with this morning's hearing?
No.
Right.
He is now online, it says.
Right. Right. Well, the court will adopt the recommendation then this morning. Obviously, if it's an issue with Mr. Manini, you can always petition the court to modify it. It appears to be reasonable.
Thank you, Your Honor.
So right now, mom has no weekends, is that correct? This recommendation every other weekend, alternate weekends, okay.
Correct.
All right.
So we basically just asked to eliminate his weekday parenting time because that was the parenting time he was consistently not exercising. He already had every other weekend from Friday at 4:30 until Monday to school. And he only recently moved to Toledo, but I don't believe that there's anticipated any issue with him being able to continue to get them to school on Monday mornings.
Okay. You can just make a note that from any future pleadings can be sent to the front of the court for service since he's got a confidential address, presumably in Toledo. But the court will adopt this recommendation of Ms. Brower this morning.
Thank you, Your Honor.
Welcome. And Ms. Brower, I seem to have lost. I don't know if I hit a wrong button. I seem to have lost your rec. Can you put that back in my queue, please?
Yes, we can get it back in your queue.
All right. All right. Thank you, Ms. Dimick. The out close, Mary, can zoom out. Thank you, Ms. Walch.
Thank you. Thank you. Have a good day.
Thank you.
On the matter, Jack Bellinger versus Michelle Bellinger.
For the record, this matter is before the court on the defendant's motion to modify parenting time and child support. This hearing is being conducted via Zoom. Present is Attorney Anthony Bresco representing the defendant moving party, Rochelle Bellinger. Ms. Bellinger appears to be present with Mr. Bresco. In addition, Attorney Christina Hills is present representing and with the plaintiff, Jack Bellinger. Mr. Bellinger is present with Ms. Hills. Good morning, everyone.
Morning, Your Honor.
Good morning, Your Honor.
The parties have conferred with Mr. Pratt from the front of the court, who has provided the court the following recommendation this morning, that plaintiff father shall have supervised parenting time with the minor child Jack every other weekend, Saturday noon until Sunday at 5 p.m. In addition, father shall have supervised parenting time with the minor child Jack Wednesdays after wrestling practice until 8:30 p.m. The supervisor shall be the paternal grandmother. Further, father shall have parenting time with the minor child Patrick on recommendation of the child's counselor. The issue of parenting time shall be referred to the front of the court for a formal investigation recommendation. In the interim, neither party shall discuss the case or disparage the other in the presence of the children. Further, neither party shall consume alcohol, illegal substances, or unprescribed drugs before or during their parenting time. Both children shall be enrolled in counseling with an agreed upon counselor. The parents shall participate with the counseling at the counselor's request. Further, with respect to the Christmas 2024 holiday, father shall have parenting time December 25th at noon until December 26th at 9 a.m. Presumably that's with both boys.
Yeah, we left the door open, Your Honor, so that it could be, yes.
Okay. Finally, as part of the front of the court investigation of parenting time, both children shall be interviewed, and the parties shall return to this court to review parenting time on February 5, 2024 at 9:30 a.m. Of course, that would be a Zoom review. That's recommendation, Mr. Bresco. Is this recommendation agreeable with your client?
It is correct. It's agreeable, correct? Yeah. Yes, it is, Your Honor.
You also raised the issue of child support. Will that be deferred, Mr. Bresco, at this time?
We just like to reserve it for now, Judge. I'd like to see how this goes. If this had turned into a long-term or more permanent change, then it was an issue. But we'd like to reserve the issue for now. Is that okay? Okay.
All right. Thank you, Mr. Bresco. Ms. Hills, is this recommendation agree with your client this morning?
At this time, it is, Your Honor, yes.
Okay. Both parties did participate in the discussions with Mr. Pratt. Would either counsel like to voir dire their respective clients regarding this recommendation?
No, Your Honor.
No, Judge.
All right. So who initiates investigating a counselor for the children, for the boys?
Your Honor, Mom has, go ahead, Christina, sorry.
I believe each party is going to check with their respective insurance and provide some names, is the way I understood it. And then if we have a match, then we'll go with that. And if not, then I believe the parties will communicate. And if they're unable to communicate, then Mr. Briscoe and I will assist.
Wonderful. All right, the court will adopt the recommendation then this morning. Copy mailed to council. Now concludes here, and everyone can zoom out. Have a good rest of the morning. We'll see everyone on February 5 at 9:30. And please make the holidays good for the boys. I mean, those things are important. Even if the boys have a strained relationship with their dad, Ms. Bellinger try to encourage that. Encourage the boys to get something for the holidays or Christmas for their dad. Those little things mean a lot, even though there's a strain there. Encourage the boys to get something, a gift for their dad with your assistance. Same with you, Dad. When they send you have contact with the boys, make sure they remember their mom for Christmas. All right, I'll conclude this here. Now we're going to zoom out and have the rest of the morning.
Thank you, Your Honor.
Thank
You
you,
too.
Thank you.
Welcome. For the record, this matter is before the court on the plaintiff's motion for custody and exclusive use of the marital home, as well as a pretrial conference scheduled by this court to move the matter forward. This hearing is being conducted via Zoom. President Attorney Russell Smith representing and present with the plaintiff, Katie Henderson. In addition, Attorney Henry Levens is present with and representing the defendant, Philip Henderson. Good morning, everyone.
Morning, Your Honor. I think Mr. Smith is still muted.
Sorry about that, Your Honor. Good morning, Judge.
Good morning, Mr. Smith. Parties have conferred with Ms. Patrick. Good morning, Ms. Patrick. Ms. Patrick has provided the court with final recommendation. Defendant father shall have the party shall share joint legal custody with physical custody to the plaintiff mother. Parenting time for defendant father should be every other weekend, Friday after school until Sunday at 6 p.m. Defendant father will also have every other Monday after school until Tuesday morning back to school. Defendant father will also have every other Monday after school until Wednesday back to school. On weeks he does not have weekend for any time. Parties will agree regarding holidays. If they cannot agree, the fallback will be the Monroe County Friendly Court holiday schedule. Further, with respect to child support, that commencing December 1st, 2024, defendant father shall pay child support in the amount of $1,643 per month. Uninsured medical expenses shall be shared by the parties as follows: the plaintiff mother paying 30%, defendant father paying 70%. Further, it's recommended that neither party shall have any unrelated person with whom they may have a romantic interest in the presence of the minor children. Neither party shall consume alcohol in the presence of the minor children. The defendant father will give to plaintiff mother the PIN number for the cell phone contract. Further, defendant father will give $1,500 to the plaintiff mother to move from the marital home. Defendant father will be allowed to sell the rental property known as 1 Gate in Toledo, Ohio, and all proceeds will be placed in Mr. Levens' trust account. Plaintiff mother, however, must agree to the list and sale price. The party shall use app close to communicate with each other regarding the minor children. That is the recommendation. Mr. Smith, is this recommendation agreeable with your client this morning?
Your Honor, I've spoken with my client, although the recommendation certainly is not what she would have picked. She's willing to agree to this temporarily. I think it's important for the parties to reach a temporary agreement and move forward. And I think that Ms. Patrick has done a wonderful job of mediating. There was one thing that I didn't hear, maybe I just didn't hear it, and that is neither party shall consume alcohol in the presence of the minor children. If that was stated, I apologize, Judge, but my client is willing to agree with this.
Yes, that provision is in the recommendation, Mr. Smith. Neither party shall consume alcohol in the presence of minor children.
Thank you, Judge.
All right, Mr. Levens, is this recommendation agreeable with your client this morning?
I echo 99% of the comments that Mr. Smith made. It is agreeable to my client. We just respectfully ask the court to add all Tuesday overnights. The parties have raised the children together. Mr. Henderson sees the kids back from school every day. There's never been any issue with his parenting with the children. We ask the court to adopt the recommendation, but expand his parenting time to include the Tuesday overnights in addition to what has already been in the rec.
All right, thank you. With respect to the $1,500 that defendant father will pay to plaintiff mother, there's no time frame for that. She'll move once she receives that?
She needs to find a place to land, Judge. Quite frankly, you know, my thought was that Mr. could live at the vacant rental unit until such time as my client has procured a townhouse or an apartment. He is unwilling to do that. And I believe it is important that the parties physically separate because of the tension that exists in the marital home. But you're right, there is no time frame on the payment of the $1,500. Obviously, we'd like that paid as soon as possible so that my client can explore that. In the interim, I would suggest that Mr. Move very temporarily until such time as this can be accomplished.
That perhaps would be beneficial to the children. Mr. Liebens, what about that proposal that your client live in the apparently vacant rental property until such time as that closes?
My understanding is it's not a furnished property and it has a buyer ready for immediate sale. My intention was to, as promptly as I can, confirm that sales price, communicate that to Mr. Smith for his concurrence per the recommendation, and get that closed, optimally within the next few weeks. Additionally, just to keep this matter going, I don't believe we've scheduled a mediation date to come back. I was hoping we could get something as soon as possible, mid, late January to come back.
Yes, the court does want to schedule this being a pretrial as well. The court wants to move us forward and schedule a mediation date. Is the marital home, is that also going to be placed upon the market? Or is one going to buy out those interests? Has there been discussion about the real estate, marital home?
Mr. Henderson intends on assuming the marital home and having the details of that resolved through the property settlement.
Okay. Is there a significant unsecured debt? I just want to get some idea of the issues. Is there a significant credit card debt that needs to be addressed and divided?
There will be, Your Honor.
I'm sorry?
Yes.
Okay. So we got unsecured debt. I'll put real property, personal property division. This is on eight-year marriage. It's not a really case for spousal support. Are there pensions that need to be divided? Retirement plans?
Yes, Judge.
Yes.
All right. Ms. Patrick, do you have a list of the available mediation dates sometime in January? The court has one on its desk. I can get that.
I can give that to the court. We have January 23rd. I would be available in the afternoon. Miss Brower is available at 8:30 or 1:30. Mr. Walker is available at 8:30 that day on the 23rd.
If we could start at 8:30, Your Honor, if that works with Mr. Smith's schedule, because it may be a little bit lengthy today, kind of lingered out a little bit. I think it'd make the most sense to give as much time as possible to the parties.
Mr. Walker is available at 8:30 or Miss Brower is available at 8:30.
Judge, my preference would be to have Ms. Patrick, since she's familiar with this case. What's your availability on that day, Ms. Patrick?
I'm only available that day at 1:30.
I would suggest 1:30 in front of Ms. Patrick. That would give us sufficient time to move this forward. I anticipate that Mr. Liebens and I will be sharing information back and forth so we can make this a meaningful mediation. So that would be my request.
Will not be available that day. I'll be out of the jurisdiction. I'd like to be available in case they're to conduct a continued pretrial immediately following that mediation. So perhaps what about the following week, the week of January 27th? Would that be too far off? Mr. Liebens, Mr. Smith?
No.
Ms. Patrick, do you have any availability that week of January 27th?
I am available, Your Honor. I can be available either the afternoon of the 27th at 1:30, or I could be available on Thursday the 30th at either 9 a.m. in the morning or 1:30 in the afternoon.
The 27th works best with my calendar, Your Honor.
It's a Monday. Ms. Patrick, you suggested 1:30 on the 27th?
Yes, Your Honor.
I have a major trial the next 2 days in front of Judge Oldsaver out in Lenawee. Would it be possible to do Thursday, the 30th in the afternoon?
Yes.
Patrick, would that work with your schedule?
I believe it does, Your Honor. Let me just double check that once again. The 30th at 1:30, yes, that works for my schedule, Your Honor.
So that works with your schedule, Mr. Smith and Mr. Levens, January 30th, a Thursday at 1:30 with Ms. Patrick?
Yes, Your Honor, I've already got it into my schedule.
Yes,
Right.
Judge.
Ms. Patrick, is it possible you could just add just a sentence, this recommendation that the party shall mediate on January 30th, 2025, 1:30 p.m. and that's subsequently appear before the court for pretrial. If you can squeeze that in somewhere.
I will attempt to do that, Your Honor.
Well, no, that's fine. With the court just mail out a pretrial notice. It looks like this form is pretty tight. So I'll just mail out a pretrial notice. Same to
Thank you,
everyone.
Your Honor.
Scheduling a mediation with Ms. Patrick by Zoom, January 30th, 1:30, and with a continued pretrial thereafter.
Perfect, Judge.
And so discovery will remain open, have the parties exchange the verified financial information forms.
We have them. We're working on them, Judge.
Okay, right, very good. Anything further than this morning, Mr. Smith or Mr. Levens? The court is inclined to adopt this recommendation. I understand, Mr. Levens, your client wants some more parenting time, and that can be addressed with Ms. Patrick in January. Let's see how things work. Counsel, do you want to voir dire your respective clients regarding this recommendation of Ms. Patrick this morning?
Yes, Judge.
This time around.
Briefly, Ms. Henderson, did you hear the recommendation that was placed on the record today?
I did.
Are you agreeable to it at this juncture?
Yes.
And you understand you have a right to a contested hearing in front of the judge? You've chosen not to do that and adopt this as the temporary agreement?
Yes.
Very good. I have no further questions.
Mr. Levens?
Likewise, Mr. Henderson, you heard the proposed agreement?
Yes.
And you understand that this is temporary and for the interim, and we're coming back as soon as possible, the end of January?
Yes.
And you do have some reservations as it in particular concerns your parenting time?
Absolutely.
And you know that this matter will be revisited?
Yes.
So with that in mind, are you agreeable to the court adopting this temporary order without prejudice, knowing full well that you're going to be coming back to optimally have a global resolution January 30th?
Yes.
All right. I have nothing further, Your Honor.
All right, thank you, Mr. Levens and Mr. Smith and Ms. Patrick. The court will adopt the recommendation. The court will mail out a notice for pretrial conference January 30th, subsequent to the 1:30 mediation with Ms. Patrick. That will conclude this matter. Everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you, everybody.
Judge, do you have two seconds to take the proofs, or would you want to do that another day?
We can.
All right. I'd like to.
I'm sorry.
FTR keeps stopping on. Hold on. I can get it going again.
Obviously, it's a DM case. We can wait till January, Mr. Smith. We're having a problem right now with our recording equipment.
Very good, Your Honor. Thank you.
We'll take the proofs when we appear in January.
Very good.
All right.
Have a good day, Your Honor.
Everyone can zoom out. Have a good rest of the day.
You too.
For the record, this matter is before the court on the plaintiff's motion to enter orders of custody, parenting time, and other relief. This hearing is being conducted via Zoom. President Attorney Ronald French, representing the plaintiff petitioner Trenton Marshall. Mr. Marshall appears to be present. In addition, Attorney Kirsten Nemick is present, representing defendant mother Madison Ferris, and Ms. Ferris is present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Judge.
Parties have conferred with Mr. Walker from the front of the court, who has provided the court with fine recommendation that the parents on a temporary basis without prejudice shall share joint legal custody of their 2-year-old child. Parenting time for defendant father shall be as specific as follows. Namely, father shall have parenting time every Wednesday from 6 to 8 p.m., every Saturday from 10 a.m. to 6 p.m., and every Sunday from 10 a.m. to 2 p.m. Then starting the week of December 2nd, 2024, father shall have every Tuesday from 6 to 8, Thursdays from 6 to 8, and Saturdays from 10 a.m. to 8 p.m., In addition, files shall have Christmas Eve, naming December 24th, from 10 a.m. to 8 p.m. Mother shall provide all transportation. Finally, the parties will appear back for court to review parenting time on January 15th, 2025, 10:30 a.m. That will be via Zoom. Mr. French, is this recommendation agreed with your client this afternoon?
It does. It comports with everything that we've agreed to, I believe, Your Honor.
Thank you, Mr. French. Ms. Nemec, is this recommendation agreed with your client this afternoon?
It is, Your Honor. Thank you.
Wonderful. Both parties did participate in the discussions with Mr. Walker. Counsel, do you want to voir dire your respective clients? Is it necessary?
Sure, Your Honor.
Okay.
I don't think we need it, but if you want us to for the record, Your Honor, we can do that.
It's not necessary from the court standpoint. I'm just offering that to counsel.
No, I'm okay with it. My client agreed, verbally already,
Ms.
so
Nemec?
we're good.
I also don't feel the need to voir dire, Ferris.
And the court would note that both parties did participate in the discussions with counsel and Mr. Walker. Very well, the court would like to thank Mr. Walker for his assistance, as well as, of course, attorneys French and Nemec for helping the parties reach their own agreement. So the court will adopt the agreement. The court finds any agreement between the parents between the best interest of the minor child. Mr. Marshall, Ms. Ferris, obviously you got a very young child. You want your child to thrive, and your child will thrive if you are both on the same page. So effective communication is the key. So please communicate. If there needs to be some modification, somebody's late, somebody's not feeling well, there's an issue with the child, and Mr. Marshall will reach out to Ms. Ferris. So keep the lines of communication open so you work together. Life will be a lot easier for both you, and your child will thrive. So with that, if we need to, we can discuss any changes that need to be made. That will come back January 15th at 10:30. But to work together, be cooperative and open-minded. If in fact, I don't know what you're doing about Thanksgiving, but I mean, it'd be nice if each parent could spend some time with the child on Thanksgiving with the extended family. But that's something for the two of you should be able to work out. You really don't want the court deciding these matters. All right, with that, thank you, Mr. French. Thank you, Ms. Nemec. That will conclude this hearing. And the court will adopt the recommendation. You're welcome. Have a good rest of the afternoon. Thank you.
Mr. Counsel.
Thank you.